appeal in the matter of Blower and GH Canfield LLP.
May it please the court.
Yes, Ms. Pope-Williams.
My name is Charlotte Pope-Williams. I appear for the appellant with Daniel Goldblatt and my learned friend, Mr. Jonathan Seatler KC, and Luke and Wilson appear for the respondent in this case. Can I just check that you've got all of the relevant materials?
Certainly.
There should be 3 bundles. So a core bundle that runs to some 174 odd pages,
Yes.
a supplementary bundle that runs to 358 pages, and an authorities bundle of 263 pages. There's just one small point to note about the core bundle, and that is that the page numbering is a little bit off on the index page. So the respondent skeleton actually starts at page 59. I'm grateful. Now, with respect to the structure of my submissions.
Well, just before you help us with that, if I can just, for your assistance, tell you all that we've had an opportunity of reading extensively into the papers in this matter. We've read obviously the judgments, skeleton arguments, dipped into the authorities, so we're well prepared. We are rather surprised this has been listed for a day and a half. Views?
So are we.
So I think we were just overcautious in terms of timing, depending on sort of the amount that each party has to say. But I would imagine, given how familiar the court is with all of the papers, that I don't imagine I'll take too long. There are only 2 points to cover in submission.
Well, I think
we'll be
just with the 2 grounds. We would we'd hope that we would finish within the day.
Absolutely, and I think it's listed that way in a
Of course, putting any pressure on you, but you know, as I say, we have extensively. Right, off you go. Tell us your structure.
Okay, sorry about that. In relation to the structure, since you're familiar with the papers already, I'll be guided by you. I had proposed to go through the facts shortly, but if that's not necessary, I'll.
Well, if you want to settle yourself in by going through the facts, please
No. I'm.
If
If you're already familiar, then there's no need to. There's no need to do that. The next item would just be the legal principles that we're relying on here. So there are 2 areas that need to be covered with respect to the submissions I'm going to make, and those are conflict of interest and causation, and also the pleading point, if I put it that way, which is rolled up with the causation point as well. So with respect to conflict of interest, it's quite simple in my submission, and it's almost summarised correctly by Mr. Allen, the trustee in bankruptcy, in his witness statement on the 25th of April 2016, which was 4 months after the mediation, where he says, as a solicitor, I'm under a professional duty not to act for a client where there is a conflict or a significant risk of a conflict of interest between a client and myself. Now that's right, but here we're concerned with a conflict of interest between clients of solicitor. So to summarise the position set out in the case law, which is subsequently amplified by the SRA code, and to use that regulatory language, what we're concerned with here is where there is an actual or a potential conflict of interest between 2 or more clients. So here we're concerned with Kelly and Mrs. Blower, and I don't mean any disrespect by referring to her as Kelly. It's just, if I say Miss Blower, Mrs. Blower,
she's called Kelly.
it will get confusing. A solicitor must notify those clients about the conflict and obtain their consent, their informed consent to act where it's possible for that solicitor to do so. And a solicitor should not act where there are 2 or more clients with an irreconcilable conflict of interest. So that's what's at the crux of
Now you're going to take us to that.
Yes, I can take you to there's a range of authorities that make this point. Probably the neatest place.
I meant the code.
Oh yes, I'm going to take you to the code, sorry. So the code starts at page 246 of the authorities bundle, or if you prefer, depending on, it's also set out in my skeleton argument as well. And in the reference for the,
just go
to the authorities bundle.
Thank you. Thank you.
So that effectively, if you're looking at the first page 246 there, you've got the key principle in relation to conflicts of interest set out, and these are mandatory provisions. So a solicitor must not act if there's a conflict or a significant risk of conflict in the circumstances. So that's set up there in chapter 3. And then if you go over the page 247, if you've got that. And if we look at the bottom of the page at 03.6, that's where you have the carve-outs to the rule. So you must not act unless you put in place various safeguards. And the code here takes you through what those safeguards are. So you have to make sure that the clients have a substantially common interest between them in relation to the matter at hand. You have to make sure that you've explained all of those relevant issues and risks to the client, and that you have to have reasonable belief yourself as a solicitor that the clients have understood what the relevant risks are. And importantly, you have to make sure that you've got that informed consent from each one of your clients, and not just informed consent in writing, so you can be absolutely clear that they've understood and you're satisfied that it's reasonable for you to act in those circumstances. And also 3.6 asks you to engage in a balancing act, as it were, to consider if sort of acting in your client's interest, their best interests outweigh the risk. So it's in their best interest to proceed, even though there's a risk created by this conflict of interest or the significant risk of a conflict of interest.
I have assumed that the highlighted terms are terms that are defined somewhere else.
Yes, they are defined in the glossary of the code, and I'm afraid that's not included in the.
Don't worry, I just, as a matter of form, if we see something that's underlined and in italics, it's because it's a defined term.
Yes, Lord. And also it's a hyperlink as well.
Say,
so
I thought they were hyperlinked.
Yeah, so you can hyperlink to
Yes.
the relevant definition in the code when you're looking at it in the online version. So that's the position in relation to conflict of interest. You must not act if there is a conflict of interest or there's a significant risk of one, and you have to get that informed consent in writing in all of the circumstances. So that's what Mr. Whitehouse, the solicitor, should have had in his mind when he was dealing with Kelly, Mrs. Blower and Mr. Blower, we say.
And do you say that outcome 3.7, which is at the bottom of page 247, applies at all or not? That's where there is a client conflict and the clients are competing for the same objective.
We say it may apply here. It depends how you cast the facts. In this case, if you accept that Mr. Blower and Mrs. Blower are acting as effectively a team with Kelly, or if you accept that Mr. Blower is trying to discharge himself in bankruptcy, whereas Kelly and Mrs. Blower are protecting their interests. If that's the case, and you have to look at 3.7.
But I'm just interested in that. Are you saying it does or it doesn't, as far as you're concerned? Because I'm then thinking about the findings of fact that the judge made, that you're not appealing, which suggests that they were working as a team, put it that way. So are you relying on 3.7 or not?
We're relying on 3.6 as opposed to 3.7.
You are, okay.
But in terms of dealing with this finding of fact, perhaps...
You'll come to that, but you are relying on 3.6 rather than 3.7.
Yes, my lady.
Thank you.
I'm grateful. So, sorry, losing my voice slightly there, excuse me. So coming on to the, try not to use my voice, coming on to the legal test relevant for causation, if you're content with the principles in relation to conflicts of interest. So the legal position in respect of causation is neatly set out in the Supreme Court case of Perry and Raleigh, which was reported in 2020 in the appeal cases at page 352. And if you want to turn that up, that can be found at page 146 of the authorities bundle. Or the relevant quotation can be found on page 146. Sorry, it doesn't start at page 146. And the relevant quotation that I'm going to refer you to can be found towards the bottom of the page. It's paragraph 20, if you can see it there. And the relevant legal principle we say is encapsulated neatly there, and it says that for present purposes, the courts have developed a clear and common sense dividing line between those matters which the client must prove and those which may be better assessed upon the basis of the evaluation of a lost chance. To the extent, if at all, that the question of whether the client would have been better off depends on what the client, so Kelly or Mrs. Blower, would have done upon receipt of competent advice, this must be proved by the claimant upon the balance of probabilities. To the extent that the supposed beneficial outcome depends on what others would have done, so perhaps a trustee in bankruptcy or Mr. Whitehouse in this case would have done, this depends on loss of chance. So those are the key principles that we say will apply in this case when we're looking at that causation question in relation to what Kelly and Mrs. Blower may have done had they been in receipt of advice about conflicts of interest from Mr. Whitehouse immediately before the mediation took place on the 9th of December 2015, almost a decade ago now. So in relation to the pleading point, so there's a corresponding point connected to causation about pleading. My learned friends will say that the appellant hasn't pleaded a complete case causation in its amended particulars of claim and that the pleadings are deficient. So the starting point is plainly the civil procedure rules, part 16, 1641A, that requires particulars of claim to include a concise statement of facts on which the claimant relies. So that's trite. And then the applicable law in terms of pleading deficiency, we say what the court may or may not do in those circumstances is encapsulated in the case of Charles Russell Speechley LLP and Beneficial House Birmingham Regeneration LLP, which is reported in 2022 in the Cost Legal Report at page 343. And then the relevant sections for that case are set out at page 179, or starting rather at page 179 of the authorities bundle. So they're quite lengthy quotes, so I
Sorry, page 179.
should be page 179. So
And it's a decision of Mr. Justice Cotter.
yes, it is a decision of Mr. Justice Cotter. That's correct. So it's starting at paragraph 61 is the quotation that I'm looking at, which is about halfway down the page.
Would you like us to read paragraph 61 through?
Yeah. So if you could read all the way through, I'm afraid it's a quite a lengthy quote, so it runs over right to page 181. It's just because it sets out the three circumstances that in which the court can deal with.
So you'd like us to read through to the end of paragraph 65?
Precisely, yeah, exactly.
Excellent.
I'm
Right, just
grateful.
give us a moment then.
Thank you.
Thank you.
Okay, I'm grateful. In my submission, we're in what I call the third category of cases here. So there's the prejudice pet test, if I might call it that, that would apply. Since a pleading point is being taken, the court has to consider whether there are issues in the case that require determination, and if the parties know where they stand in relation to those issues. And also in considering that, the court will have to consider if prejudice will be caused by considering those issues. And it's this prejudice might, and might in relation to the prejudice is quite a low bar. And so if that threshold is crossed, then really the appropriate action would be to amend the statements of case, albeit it's not a hard bar, and there may be circumstances, depending on the context of the case, where it might be appropriate to allow a party to depart from their pleaded case. So that's the pleading point covered off in terms of the applicable legal principles. And the final point to round up before I develop my submissions is the quantum point. Just to highlight that insofar as this court is with the appellant, then damages may have to be determined. And in my submission, we're not well placed to do that here today, but the appropriate course would be for the court to remit or refer this case back to the lower court in accordance with its powers under CPR 52.20. Where this court has the full powers of the lower court and can remit an issue for determination to the High Court if that's appropriate in all of the circumstances.
Do we have another issue in relation to that about the conflict point? You say leads to consequence that Mrs. Blower and Kelly, if I call her that, would not have had the settlement agreement signed on their behalf, and I think it's pleaded as wouldn't have agreed to that or at all, in the sense that they wouldn't have agreed to anything. Now, in relation to that, you've got findings of fact about what they would have done, albeit on the basis that the judge finds that for having gone through and winnowed out each of the arguments in relation to the different strands of claim and defence, that there was no conflict. But he nevertheless finds various things about the family dynamic and what was going on. And those matters are not challenged. So are you saying, I don't know, I just want to have it clear in my head, that actually also we would have to remit for further findings in relation to what the position would have been had they been properly advised about the conflict and what they would have done?
I think no. I'm grateful for the guidance in the question. The submission that I'll be making later on in relation to the quantum piece, if I can call it that, is that the court needs to look at what the trustee in bankruptcy would have done in relation to the specific causes of action that were contemplated in that mediation paper. So namely, you're looking at the flat 201 application, if I can call it that, and the potential declarations in relation to the £666,000 odd against Mrs. Blower as well.
But doesn't that require us to make findings of fact? I don't know. I'm just.
In my submission, it's a prospects question. So first you would look at well, what would Kelly and Mrs. Blower do in the circumstances? We would say that they wouldn't have signed up to the settlement agreement at all, and they would have fought those applications, in which case, like any barrister or solicitor would do, you'd have to say, well, what are the prospects? Because that's a loss of chance question.
Okay, that's the loss of a chance.
That's a loss of a chance. Or in the alternative, if you're looking at it saying that, well, they would have signed up to a settlement, we've said we'd signed up to a settlement, but it would be at a much lower amount than the actual amount that they paid or the amount that was proposed. Again, that's a loss of chance assessment of, well, what would the trustee in bankruptcy have done in the face of Kelly and Mrs. Blower having had that conflict advice and being separately represented, and pushing back on what the offers were that were made. And we say that there is actually information in the court file that assists the court in dealing with that. So actually what you're looking at, particularly because when you look, for example, at the mediation position paper and the offers that were made in that mediation position, so in that mediation, there's a typed up note of it. You can see that the trustee actually was considering lower offers to Kelly and Mrs. Blower on an individual basis. So that would assist the court in making that assessment of what the loss of chance would be. So it's not so much finding of facts in my submission, that there will be a degree of that because there's a mix of law and fact here that we're dealing with. But really what we're considering are the prospects of success of the relevant actions that were on foot or potentially on foot by the trustee in bankruptcy, whether that be if they went sort of into formal proceedings or whether that be in relation to settlement is what we're dealing with.
So therefore, I'm sorry, I'm taking you off track a little bit, but you said that the damages might have to be determined having remitted the issue. This loss of a chance element would be part of that, would it? And therefore the judge, when they're looking at that, if we remit it, would also have to consider this loss of chance point.
Yes, my lady, that's exactly the point I'm making, and it builds on.
Sorry.
Oh no, I'm sorry, I didn't mean to cut you. I apologise.
No, the reverse. You're saying that's exactly the point you're making. I'm sorry that I hadn't distilled it in my mind in that way.
No, I was going to. You've taken me to the end before I gone through, but which is absolutely fine. But the point that I would make, and it builds on the Charles Russell Speechley case law, where the Mr. Justice Cotter alight on the fact that cases do need to be pleaded properly, and that's well understood, so that we understand what we need to do when we turn up in court. However, which is fair enough. However, in that case, what happened was a retrial was ordered. So it wasn't that the issues weren't determined. It wasn't that the court was saying that there isn't anything to do here. It's that the court said, well, the parties haven't had a fair crack at making sure that they can put submissions about the relevant implied retainer point. And my submission towards the end in relation to causation will be, if the court accepts that we have a negligent solicitor that failed to give appropriate conflicts of interest warnings to Kelly and Mrs. Blower, the answer cannot and should not be that that negligent solicitor is allowed to escape liability off the back of a pleading point, where there is a practical solution that can be provided by this court by remitting it back to the lower court for determination as regards the quantification issue, and also in fairness to the respondent on the other side in remitting the matter down. That allows the respondent to make submissions in that regard, because that would be the key prejudice, is that the respondent hasn't had an opportunity to properly understand and ventilate their submissions in relation to that quantification point, if I can put it that way. So there you don't have Mrs. Blower suffering without her loss being sort of compensated, but equally giving the respondent a fair opportunity to put what they have to say about that quantification issue, if the court is minded to find that the appellant was the respondent rather, was indeed negligent by failing to give the conflicts advice, and a different outcome would have ensued if that conflicts advice had been given. So that's sort of the ending of my submissions. But if I could come back to to the beginning, I plan to deal with conflicts of interest first, right, and then come into the causation point. So the conflicts of interest point is a relatively simple one. In the appellant submission, there were, or at least could have been, potential conflicts of interest between Mrs. Blower, Kelly, and her husband / Kelly's father. And Mr. Whitehouse had a legal and regulatory duty to warn Mrs. Blower and Mrs. Kelly of those actual or potential conflicts. And I flagged that at paragraph 20 of my skeleton argument. So in my submission, not only did Mr. Whitehouse fail to recognise that conflicts existed at all at the material time just before the mediation, it only seemed to have come to him later in the spring of 2016. He also failed to advise Mrs. Blower and her daughter of the existence of those conflicts of interest because he didn't appreciate that they were there in the first place. And therefore, he also failed to correspondingly seek their informed consent to those conflicts of interest. And Canfield, acting through Mr. Whitehouse in our submission, were therefore negligent in that regard, and they breached the duty that they owed to Kelly and Mrs. Blower. Now, in our submission, the judge just didn't deal with those points. If paragraph 114 of the judgment, as observed by Lord Justice Zaccaroli, it's only a few lines there, and the judgment just doesn't grapple with any of the SRA code or any of the relevant case law.
Was the SRA code put before the judge?
It was, as I understand it. I wasn't counsel at first instance, but I believe the SRA code was put before the judge. Not only that, but the SRA code was certainly put to Mr. Whitehouse in cross-examination. So it was in issue at the trial, and as part of my submissions, I will be sort of highlighting what Mr. Whitehouse said in response to those SRA code of conduct rules being cited to him by leading counsel at first instance. So as regards what the judgment actually said about conflicts of interest, just so that you have it, it simply says, and this is in a whole bundle, and she just tries to find the reference just now, sorry.
So 114.
Yeah, it's 122. It's because there's 124 and 124 and 122 and 114. The claimant's claim, if any, would lie against her husband. Once again, the trustee in bankruptcy would have been able to exploit these points in any trial of his claims. The disposal of the trust fund also disposes of the allegation of the potential conflict of interest between the claimant and her husband. In my submission, that finding can't be right. The trust fund issue in my submission is at the heart of the conflict here. Mrs. Blower potentially had a 2 million or almost 1.5 million pound personal claim against a man that she had been married to for over 40 years, someone who would therefore have effectively squandered all of the monies and the assets that she had built up, or they had built up together over their lifetime, and that she had relied upon him to keep safe and secure, and that would have been squandered, whether it be through the interventions of NatWest or otherwise. In my submission, that creates a fundamental conflict of interest between husband and wife. They ought to be, or they may be, thinking about different things and pulling in different directions. Mrs. Blower, even though my learned friends will say that she might not have been able to get any money back if she proved in Mr. Blower's bankruptcy as an unsecured creditor, nonetheless, as an unsecured creditor, she has a fundamental different interest to Mr. Blower as the bankrupt debtor. And there's a conflict there. Mr. Blower's interest is to be discharged from bankruptcy and to escape that, and according to Mr. Whitehouse, to at 76 years old go on and continue in business, which he may well have done despite his cognitive decline. Whereas Mrs. Blower's interest is trying to protect or claw back some of those assets that she's built up over almost half a century. And that's, even if you don't accept that it's an actual risk, we say that it is a significant risk of conflict between those parties pulling in different directions.
How
And in
do we-
those circumstances,
Sorry to interrupt.
Yeah.
How do we test whether it's a significant risk, and when do we test it's a significant risk?
In my submission, in terms of the when, similar to lots of our professional codes, this is an ongoing obligation that subsists throughout the course of the retainer of the solicitor. So it may well be that during a matter things are fine at the outset. So we had Mark Hubbard representing the parties in relation to that first hearing for Flats 201, where they had a common interest at the start of trying to defeat the bankruptcy's claim in relation to that flat. But as things developed, and for different aspects of the case, it may well be that a conflict of interest may arise in the circumstances. Whereas here, in my submission, in relation to the trust fund issue, and that's the issue that's pleaded in the amended particulars of claim, that issue subsisted from at least 2014, we say, where Mr. Whitehouse went to see who he referred to as Lexa Hilliard of counsel to get advice about that trust fund. So it was a live issue well over a year before this mediation happened. So at that time, there should have been a consideration of, well, is there a risk here? And indeed, Mark Hubbard, even when he was dealing just with the Flat 201 issue, alighted on the fact that there could be a conflict of interest, given that barristers have similar obligations to solicitors in this regard, and considered that Kelly might need separate representation through counsel compared to her parents, because there could be a tension there where she was seeking to have a beneficial interest.
And what does significant risk mean? Does that mean that you, as counsel or solicitor, evaluate the merits of the particular situation, or what?
Oh no, absolutely. There has to be an evaluation, and that's what's set out in the code, that you're having to go through those evaluative steps to see if, in your mind, is it reasonable. So you're thinking, is it reasonable for me to act as solicitor in those circumstances, and you're having to weigh up the risk and the benefits to proceeding in assessment. So you're going to have to look at all of the material factors to see the materiality of that risk. Is it something where one of the parties could suffer prejudice compared to the others, or where in particular, where you're looking at certain aspects of the case, or where in particular you have interests where you might have to breach your duty of confidentiality in relation to... Sorry, I don't...
No, I don't want to cut across you, that's fine. Yes, I understand those things. But as the solicitor, when you're weighing up whether there's a significant risk, do you evaluate the merits of the claim, for example, in relation to the trust fund, and conclude actually, on the evidence doesn't look as if it has any legs, or, oh yes, it does. And if it's, oh, this particular claim has no legs, then there's no significant risk of conflict. Do you do that merits evaluation in order to decide whether there's a significant risk of conflict? Or do you say, I see that potentially there are these arguments for a person in that situation, and those on the other side, accordingly, there's a potential for significant risk?
In my submission, my lady, it's the latter, but also I'd make the point that you also have to take a step back when we're thinking about these regulatory obligations, and also think about the personal relationships involved. It's almost like you have in this kind of Ettridge type position, this sort of I have the Ettridge case in my mind. I appreciate that it's not in a bundle, where you have husbands and wives, or in the Moat case from New Zealand in a Privy Council, we had a mother and son, where the mother was taking out a mortgage on her house to fund her son's business endeavours. So it's not just a function of looking at the merits of the transaction or the merits of the case. You also have to consider from a regulatory perspective if there are any conflicts arising in relation to the personal relationships between the relevant parties. It's not just a purely legal merits-based question. And it's the same way if I was related to someone on the bench, I would have to think about that from that perspective as well, if that was okay. Or if I was related to a solicitor would be a better example, one of my professional clients, that's something to think about in terms of that conflict of interest position. So it's not just a function of looking at the merits of the case. You have to consider the personal relationships involved, and the proximity of those relationships isn't an answer to a conflict point. In fact, it can make it even worse. Exactly. You might be blinded, and that's why it's so important and why it's enshrined in the SRA code that you need to seek that informed written consent, and you ensure that the parties understand what's going on. The judgment clearly alights on, just to come back to my submissions, precisely what the issue at hand is, that being the trustee issue at paragraph 95 of the judgment, which is at page 115 of the core bundle, and summarises it neatly, that if properly advised, the claimant had a claim against John Blower's bankrupt estate for the sum of £1,424,574 held on trust by John Blower for the claimant, or in the alternative, the £2 million held on the deed of trust. Now, in the respondent's skeleton argument, they say that the only reference to conflict of interest that the appellant can rely on is this ability to set off liability against the trustee in bankruptcy, and that's at paragraph 8.2.3 of the respondent's skeleton argument, and that's at page 67 of the supplementary bundle. But in our submission, that's not right. That's not what the appellant was saying. In our submission, paragraph 38A of the amended particulars of claim clearly states, and just for your note, sorry, that's at page 141 of the bundle, so of the core bundle, sorry, it's jumping around between the two, that a conflict of interest arose because of Mrs. Blower's claim against Mr. Blower. It states that in terms at paragraph 38A, and in my submission, that respondents are conflating two separate paragraphs, paragraph 38 and paragraph 44 of the amended particulars of claim. So in relation to what Mrs. Blower says about the conflict of interest point, just to take you a little bit through some of the evidence in this regard, in her witness statement, which can be found in the supplementary bundle at page 209, it goes over to 210. Now it's a sort of a bit of a lengthy sort of recitation, so what I'm going to do, if that's okay, just while you turn that up, summarise what she said about conflicts of interest.
201.
209.
Starts
Sorry,
at
thank you.
the section
200.
starts
So it
at
goes. It
209.
starts at 209.
Thank you.
And then it goes over the page to 210.
Which paragraphs are you looking at?
So I am looking at 97 all the way through to 105. So it just goes over the page there. And just in summary, while you look at those paragraphs, she said that Mr. Whitehouse made no mention of conflicts of interest, despite Mr. Hubbard, so this is in relation to this flat 201 claim, raising concerns. She appreciated that it wasn't in her best interest for her and Kelly to instruct the same solicitor as Mr. Blower. And Mr. Blower, Kelly's and her interests were not aligned because Mr. Blower was trying to discharge himself, or get discharged rather, from bankruptcy, whereas Kelly and Mrs. Blower were trying to protect their assets. And that's understandable in circumstances where Kelly had 2 small children and Mrs. Blower had built up these assets over the course of time. So that's what she says in relation to conflicts of interest.
I'm sure it's my fault. Why are we looking at this? Isn't this a point of law? You say the judge failed to deal with conflicts of interest. We're not island hopping through the evidence, I hope.
No, my lord, it's just that
Was Mrs. Blair cross-examined?
she was cross-examined,
So-
and the point, I can give you the references very, very briefly because I appreciate that you are very familiar with the facts. It's just to highlight the point that she did hold fast to this trust fund point, because this is what we say is at the crux of the conflict of interest issue, that she held fast to the point that she did have a trust fund and that Mr. Blower ought to have protected that trust fund. And you can find those references for your note at 227, 230 and 233 of the supplementary bundle, just in terms of the relevant sections of the cross-examination where she held fast to that point.
These are pages
So the-
227.
So 227, and you've got there's page numbers within the
Yes.
transcript. Page 47, lines 5 to 24,
Page 47. Yeah.
and then 48 on the same page, lines 19 to 22,
Yes.
and then you've got page 230, and you've got internal page number 59, lines 14 to 17.
Yes.
And just last two, page 233, internal page 70, lines 10 to 13. And 233, internal pages 81.
And I'm sorry,
Same page,
same
233.
page. Sorry. Yeah, 233 again.
Internal pages 81 to 82, lines 16 to 25, and 1 to 3.
But so at all these points, she held fast in relation to her trust fund.
She held
But
fast
of
in
course,
relation.
but the judge found that it was debatable, let's put it that way, that the trust fund had ever existed.
Which is understood, but that doesn't mean that the trust fund didn't exist. And I would submit that the trial last year was not a trial of each and every one of those the trustee and bankruptcy claims. The court didn't have all of the evidence. It wasn't a mini trial of those issues. He didn't make a definitive finding that in fact the trust fund didn't exist. He did make those findings that would be difficult in relation to all of the defences that Mrs. Blower and
Went
Kelly.
as far as to say that at some stage in cross-examination, Mrs. Blower had accepted that the monies have been spent, at least.
Yes, that's correct. She accepted that the monies had been spent, but in my submission that compounds the conflict
I see,
of,
I understand.
of interest point, and it doesn't mean that she would have absolutely no hope whatsoever of potentially pursuing an action in the future when the matters are properly ventilated.
And that's back to loss of a chance.
Precisely, my lord. Precisely, my lord. Just to take on some of the points that my learned friends make in their skeleton argument to push back against this conflict of interest point at paragraph 8.2.1 of the respondent skeleton argument, which is at page 66 of the core bundle. The respondents appear to argue precisely to the point that you just made, my lady, that because there were potential issues with Mrs. Blower's trust fund as alighted upon by Mr. Justice Matthews, that there could be no conflict of interest. As I gave the response to your question just there in my submission, that can't be correct. That actually compounds the conflict of issues. subsequently, the respondents go on in a few of the paragraphs. So for your note, the paragraphs are 8.2.2, 8.3.2 and 8.6 to 8.9 of their skeleton argument, which those paragraphs are found at page 67 running through to page 70 of the core bundle. The respondent's skeleton argument says that there was no conflict of interest because effectively Mr. Blower didn't have any assets against which Mrs. Blower could claim if she was an unsecured creditor trying to prove in the bankruptcy, and there couldn't be any set off under the Insolvency Act 323 because there wasn't a mutuality of obligations or claims between them. Now it's accepted that the 323 point is accepted. There aren't mutual claims between Mr. Blower and Mrs. Blower on the facts that we have before us today. However, in response to that, my submission is that the fact that Mr. Blower doesn't have any assets, again, is no answer to the conflict of interest point. And indeed, it compounds a point. It makes it so much worse because that means your assets that you built up over a lifetime are gone. And your husband that you love, and they've said that they're a really close family, has done this to you. And in fact, during cross-examination, we saw that Mrs. Blower was brought to tears at the prospect of this money being potentially paid away. So again, there was a real risk there that Mr. Whitehouse ought to, in accordance with his regulatory obligations, have
There wasn't a risk of it being paid away because the judge found as a fact that the bank had taken as a bona fide purchase.
As a yes.
In relation to both the first tranche 500 and the
400
subsequent.
The 500. Indeed. But in my submission, again, that compounds.
And the judge found that Mrs. Blower's intentions in relation to that money were irrelevant. No challenge to that finding of fact.
Or her intentions might not have been relevant, but in my submission, that doesn't detract from the obligation on Mr. Whitehouse to warn her before the mediation in terms of point in time about what those conflicts were. So further, and building on that point again.
Does that make any difference to your alleged loss of charm?
In respect of her intention, sorry, could you repeat the question for me? Sorry.
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 And it may not take us any further at all, but just reading paragraph 61 and 62, rereading in the judgment,
Yeah.
which, as I say, are the findings about the bank taking as bona fide purchaser for value, and the finding about your lay client's intentions. I just wanted to know where you fit those findings into your case at loss of chance.
In relation to,
Or do you say it's irrelevant?
well, in my submission, it's not relevant in relation to what the trustee in bankruptcy may have done when weighing up the costs and benefits of pursuing litigation or settling. Is not looking at what Mrs. Blower's intentions were. Well, no, sorry, that's not correct. I backtrack on that.
Take your time.
It will be no. Sorry, I'm trying to think on my feet and coming up with entirely.
No, you're doing very well at thinking on your feet. We're firing a lot of questions to you.
No, that's fine. In my submission, absolutely, it's something that the trustee in bankruptcy would weigh in a balance. But what I would say about the findings throughout the judgment is that Mr. Justice Matthews wasn't necessarily looking at the matter with all of the relevant considerations in his mind, because he dismissed this conflict of interest issue, and he wasn't looking, in my submission, at quite the right hypothetical, because in his mind there's no conflicts of interest here. You don't need to think about that. That's done away with. Because the family are a unit, and he's treating Mrs. Blower, Mr. Blower, Kelly, they're just one homogenous mass. And so they're acting as a unit. You don't need to think about these things. But if, in my submission, he had actually turned his mind to the conflict of interest point, so the question is what would happen in the circumstances where she had been advised of that conflict? How would she present the case in those circumstances, there may well have been a change in the approach taken. But I will hold that in my mind, my lady, when I'm coming through to the causation bit to see if I can address that more effectively once I get to the
Thank you.
to the causation
Thank
piece as well. I'm grateful. Just the other last couple points to address, just in response to my learned friend's points in their skeleton argument as to why they say this conflict of interest issue is an absolute nonsense. Effectively, is they appear to assume at paragraph 8 generally the conflict of interest point is contingent on Mrs. Blower and Kelly being able to prove in Mr. Blower's bankruptcy successfully, so being able to get some kind of dividend out of the bankrupt estate. And in my submission, that is not the right way to look at it. It's to look at whether there was a potential conflict by virtue of this trust fund at all, whether they're able to prove or not might compound that conflict or lessen it depending on how you look at it, but it doesn't detract from the fact that there is a conflict there at all in the first place. And crucially, and to the questions that the bench asked earlier, the respondent's position at paragraph 8.3.1 of their skeleton argument, which is in that page, it's at page 67, but the relevant paragraphs run over to page 70. They submit that the Blowers' interests were effectively aligned. And in our submission, that isn't quite right. That's not what Mrs. Blower said, and that's why I highlighted that first section. I appreciate that the court doesn't need to be taken through all of the facts, but that's why I highlighted those sections of Mrs. Blower's witness statement. She said her interests weren't aligned with her husband. She wanted to protect her assets. Kelly wanted to protect her assets. Mr. Blower wanted to be discharged from bankruptcy. He wanted to escape so that he could get on, according to Mr. Whitehouse, with his business dealings. And the final points to make is that in relation to paragraph 8.3.4 of the respondent skeleton argument, which is about whether Mrs. Blower would have had to have liquidated her assets, which we say if she'd received conflicts advice and had adequate time to deal with these things or defend the claims or reach an alternative lower settlement, that wouldn't be the case. And also we'd say that this is really a question of loss and quantum, so that falls into what I call the loss of chance bucket and falls for assessment at a later stage. And further, that is not an answer to the conflicts of interest point. We say whether she had to liquidate her assets or not doesn't resolve the problem of the potential existence of this trust fund and the differing interests and a need to give this warning under 3.6 outcome in the rules. Just to wrap up, I don't have much more to say in relation to conflicts of interest, but it is important in my submission just to highlight what Mr. Whitehouse said in response to the conflict of interest point, because in my submission that is what's at the crux here, to show that there was negligence afoot, and that can be found at page 329 of the 329
The supplementary bundle.
of the supplementary bundle, where you've got the transcripts in there.
329.
Yes, 329. And it starts, because they've got strange little paragraphs, but it starts on a left-hand side, and sort of the cross-examination sort of goes over to the right hand side because the way the pages are printed. So it's the question on the left hand side towards the bottom where leading counsel says nobody understood except you. If you can see where that. Have you got that there?
So page 329,
Yeah.
which of the internal pages?
166.
Yeah, 166. Sorry, yes, my lord, that's correct. So if you
166, and the question is?
nobody understood except you that John Blower was being told by the trustee. That's where the section starts. If you've got that.
Does it start? Sorry. Does it start a little ahead of before that at 165 at line 12?
It does. So I was trying to give you the neatest sort of
No,
neatest
I'm
thing, but they're
sorry.
not. No. It's difficult.
Just like I highlighted on the word conflict.
That's okay.
Because it might be
That's
said
the
that the passage you've drawn our attention to at 166 doesn't even contain a question.
It doesn't. No, it's a bit of a
Whereas
stereotype.
as my lady in 165 there is at least a question.
Yes.
Wasn't that an obvious conflict of
Address.
interest?
Yes.
Even I can
Yeah.
understand that.
Yes. Apologise, Laura. Yeah. So if you start there, I'm not going to read it all through because it goes all the way through onto the other page. So I'm just going to bring up my physical copy just here because my laptop has decided not to cooperate. Sorry.
You do manage to get a question and answer further down.
Yeah, exactly.
And it goes down to 168, does it?
Exactly.
Where he finishes off.
Yeah,
saying,
exactly. That's exactly right, my lord.
I thought I was acting with the full consent.
Sense of the part.
But the concession, I think that you're wanting to highlight goes from 166 into 167. Conflict of interest. It's obvious, isn't it? As a formal proposition.
Precisely, my lady. That's exactly
That's
it.
the concession you're
Yeah.
relying on, I think.
Yes, my lady. And in my submission, that's the fundamental point. Mr. Whitehouse here in the cross-examination acknowledged that he had the SRA obligations, and to the question that you asked earlier, those SRA obligations were put to him, and he acknowledged that they applied, and he also acknowledged that, well, as a formal proposition, I'm not sure what other proposition that they could be. We have to comply with our regulatory obligations, and he didn't. He said he understood them, and he didn't get the informed consent. And if you look at the questionnaire just on 167, it says that the handbook actually guided you through the process, and leading counsel set out that 0 point outcome 3.6. They're taking Mr. Whitehouse through the steps, and he said, no, I didn't do that. And in my submission, that is a clear breach. That is negligent. He had an obligation to tell Mrs. Blower and Kelly about the potential conflicts of interest here, or the actual conflict of interest, we say, in relation to the trust fund. And he just didn't do that, and he admitted he didn't do that. And that didn't seem to impact on Mr. Justice Matthews' mind. So in my submission, just to
I mean, to be fair to the judge, I mean, his very clear approach was what we find at as was the solicitors at line 12.
Yeah, just
acting with full consent, acting in their best interests at all time. Realities, there was no conflict amongst the family members. They acted together. They wished to have a golden global.
Yes.
Well, I
Yeah,
expect they wished a golden one as well.
yes, we got golden and global.
Global.
But in my submission, that
You say that's not enough.
that's not enough.
That
That's
doesn't
not right.
relieve
These are-
someone from their obligations under the regulations, is your case.
Absolutely, my lady. These are the separate autonomous human beings. Kelly and Mrs. Blower are not Mr. Blower, and deserved.
Well, I don't think you care really much about that, do you? You're saying there's a clear breach of the regulations.
Absolutely. And those are the points that I wanted to make in relation to the conflicts point. So I'm just checking.
I think your junior wants a word.
Oh, sorry. Just the final point to make in relation to Milady's earlier question in relation to 3.7 in the alternative, that if you're not with us and you say that they were competing for the same interest, and to follow on from Mr. Justice Matthew's notion that everybody's working as a whole, and even still in those circumstances, looking at that concession, Mr. Whitehouse didn't give the relevant warning, which is ostensibly very, very similar, albeit that you're looking at the common interest. There's still negligence there, even if you're not with us in that regard. So unless there's anything...
Right, on to causation.
Conflicts, okay. Causation. So the starting point is whether causation was adequately pleaded. Now, the appellant has argued that it was in the amended particulars of claim. However, if the court
You
isn't...
say it was.
Well, we've initially said that it was, that they set out the case at paragraphs 38A.
Well, let's have a look at those.
Of the amended particulars of claim. It's in paragraph 48 of the amended particulars of claim. So it's pages 141 all the way through to 144 of the core bundle. So 38A is the what I call the conflicts allegation, which you've probably seen sort of multiple times. And
it's put as potential conflict. And I think that is, although we talked about significant risk, etc., I think that is how it's put, in the sense of, and that's why I asked you about whether one had to look at the merits, etc., as a solicitor, and work out whether there was a real conflict. But it's pleaded as potential, and I think in the handbook, potential is enough.
yes, potential is enough, Milady. And indeed, there's in my submissions absolutely potential conflicts here when you look at the trust fund issue and the beneficial interest issue in relation to Kelly. And the issue that my load of friends take is that they say that we haven't said what would have happened if the claimant had been properly advised. We say that that's set out at paragraph 48 of the amended particulars of claim at 144, which is that had the defendant properly so advised the claimant, she would not have agreed to the settlement compromise and settlement deed, and or she would have agreed to settle for a sum lesser to that which she was committed to. Now, the only answer I can have for you, because I would anticipate that your next question or comment maybe, but that doesn't tell us what the trustee in bankruptcy would have done in the face of that refusal to settle, is that the only answer I can find is that it's implicit in that pleading that the court would have to deal with that as a corresponding as a corollary for that pleading. However, I accept that the court may not be with me in that regard, which brings me really to the meat of these submissions, which is, should the court determine this matter in relation to causation outside of the case as pleaded in the amended particulars of claim. And in my submission, it should, because the matter really does require determination if the court is with the appellant that there was a conflict of interest and there was negligence, and also if the court accepts, and this is open at the moment, but if the court accepts that Mrs. Blower and Kelly Blower either would not have signed up to the settlement that was made.
How can we do that? That's a finding. That would be a finding of fact.
That would be a finding. I accept that, and it's uphill battle. But this matter just wasn't. This was just not a matter that was considered through the lens. I appreciate that the judge did look at these matters and did look at the alternative case in those paragraphs 124 to 130 of his judgment. But in my submission, he didn't look at these matters in quite the right way, because his mind did not consider, or he wasn't thinking about this conflicts point that we just made. He didn't make that determination. So it's something that, if that is right, that there was a conflicts point, then this matter will fall for determination. Otherwise, as I said earlier at the beginning, when I got to the end, before I got to the conflict, that you'll have a negligent solicitor that didn't give the right conflicts advice. It may well be that Mrs. Blow and Kelly has suffered loss, and there's no remedy
But
there.
professional negligence claims, in my experience, almost always stand or fall on causation. And the judge here, from 125 onwards, goes on to deal with what the position would be if, contrary to his view, the solicitor had been. So isn't everybody bound by that? These are his findings. If there had been negligence, he finds there wouldn't have been causation. No loss was caused. So, and he explains why. So isn't it going it a bit to say that we could conclude that your clients wouldn't have signed up to the settlement, which appears to be contrary to what he found?
In my submission, this is where sort of whether causation can, sort of building on the Zaccaroli order, whether causation can be made out a different way when considered in light of the conflicts point. When Mr. Justice Matthews is looking at negligence, he wasn't looking at negligence from the perspective of Mr. Whitehouse having failed to give this conflict of interest advice, which would have...
That was negligent.
Yes, that is negligent, but as in the type of negligence in my submission is important, because that would have impacted what we say the claimant would have done in the circumstances, and that is not something that Mr. Justice Matthews would have looked at, because he dismissed the conflict of interest point out of hand. He wasn't looking at it in that way. In my submission, he was looking at it from the perspective of, okay, we've got a family here, they are acting in concert together, and here there may have been negligence in so far as the agency point, and so far as Mr. Blower through Mr. Whitehouse could not have been the family's agent, but he didn't turn his mind to the conflicts point. It just wasn't something in my submission that he actually sort of decided, but he did put this in issue by going outside of the pleaded case. He has put this matter sort of in issue, and it does fall to be determined if...
We'll come on to that, but the first point is you'd have to say that although he did make findings based on negligence, you have to say that he didn't make them on this particular type of negligence. But I've noted you down. He doesn't deal with this type of negligence.
If you're relying on the way Lord Justice Zaccaroli put it in his order, had the judge concluded differently on the conflict of interest point, then it's arguable that he could have come to a different conclusion on the extent to which a discernible case on causation was pleaded or in any event made out. And that's what you're trying to build on.
That's effectively it, and Lord Justice Zaccaroli put it much more sort of neatly.
He wasn't standing in front of us trying to argue it. Don't worry about that.
but that's effectively it, because it's at large in my submission, because this just wasn't something that the judge engaged with, and in my submission that was wrong. And he should have done so.
And so your point is in fact something a bit different. What you're saying is, based on Lord Justice Zaccaroli, if conflicts had been at the forefront of the judge's mind, he would have dealt with the whole matter differently. but I think the Charles Russell Speechley point is slightly different, or maybe you can correct me if I'm wrong, which is even if it's Mr. Justice Cotter is saying even if it's not directly pleaded, there are circumstances in which you should go outside those pleadings. And then, in that regard, what is being said against you is, again, something slightly different. Yes, the judge said, no, it wasn't pleaded properly. But then on the basis of what he had got, which was the closing submissions, he went through whether they had any legs and he dealt with that. So that's why it's being said against you. He went outside the pleadings. He went as far as he could on the basis of what he had. But your point is slightly different, I think, which is actually this is a completely different scenario which he didn't take into account and he should have done.
Yes.
Okay.
Yes, that's exactly right. As regards just looking at causation and what should be done, building on this Charles Russell Speechley case and a relevant test, the gateways is whether a pleading point has been taken, and that is the case. So we're firmly into what I call the prejudice test territory. Sorry.
So no, we're just trying to build it together. Okay, so the paragraph 130
of
the judgment, I beg your pardon. Going back to what you've put to us, that your lay clients would not have agreed to the settlement. Ignore the bit about reversal of evidential burden. I'm not concerned about that for the moment. But there's a finding of fact there. Having heard evidence and cross-examination, that neither Mrs. Blower or Kelly would have defied Mr. Blower and refused to agree the terms. The whole family was under pressure, etc., etc., and was satisfied, making a finding of fact that they would have conceded, would have let Mr. Blower make the decisions, and that was what was the intention of the family going into this mediation. Now, that being a finding after oral cross-examination rather than pleadings, just slot that into your submissions about how the failure to make a finding of a conflict of interests helps you.
Yes, just in relation to that point, there are 2 points to make, and that building on some of the questioning that I've just had as well. In relation to the judge's consideration of the case out with the pleadings, in my submission he looked at it from the wrong temporal point, so he's looking at the wrong point in time in my submission, because he assumes that Mrs. Blower and Kelly would show up to the mediation and that it would in fact occur. And when you're looking at the conflict of interest point, you have to take yourself back in time, because you have to think about when that conflicts of interest advice should have been given. In our submission, it should have been given in advance of any mediation, because then that's going to tell you, do you need separate representation, etc., etc. Do you want to act as a mass or not? And if the judge had looked at it at that point in time, this is why it's a different consideration, then he may have, building on that Zaccaroli point, reached a different conclusion, or looked at things differently, because in my submission he was looking at the wrong point in time. He assumes that the mediation absolutely would have happened, they would have shown up, etc. So he didn't think about it from that perspective. In response to your question about paragraph 130 and that finding of fact, I would submit that this is a close family, and it wouldn't necessarily involve defiance of Mr. Blower to have separate or distinct representation as a consequence of advice about conflicts informed advice. So actually in my submission, the reason why it's not challenged is because it doesn't necessarily follow that because Kelly and Mrs. Blower would have received the right advice about the potential conflict, that it would have resulted in an act of defiance, and that Mr. Blower, as a consequence, who's a third party, sort of in that dynamic, that he would necessarily have said, well, you must turn up to this mediation. In a close family, he may well have appreciated that actually the best interests of everybody are served by doing things differently in the circumstances.
Doesn't that require us to make findings of fact in the counterfactual about what would have happened?
So in the circumstances, it
Confused.
No. I think that the court is going to have to look at what would have happened when you look at that temporal piece as well, because we're thinking about, well, what would have happened if Kelly and Mrs. Blower had received the conflicts advice in advance of the mediation? Is it right that they would have either sort of settled for a lower sum, as we say, and that's where you've got that loss of chance element coming in relation to what the trustee in bankruptcy says, or is it the case that they would have sort of fought through and defended the actions against them? And in my submission, in terms of this differential approach piece, that's something that the court in my submission would have to engage with if we follow through with the conflict of interest finding being negligent. So that there has to be, it's an issue, it is in issue. And Mr. Justice Matthews put it in issue by looking at the unpleaded case, but from our perspective or in our submission, he looked at it from the wrong temporal lens and also didn't consider the conflict of interest point when looking outside of the pleaded case. So I'm just checking that I'm okay for time.
Can you help me then with the loss of a chance? Because I think that too is a different point to the pleading point. Obviously on causation, your submissions have made it plain loss of a chance is front and centre as to how you now put it. Isn't the difficulty that you have with that the loss of a chance was entirely disavowed at first instance? I mean, we're used to people standing up and saying, oh, look, the judge got it wrong. Here were these 2 points and he decided X and he should have decided Y. But it's unusual in my experience for counsel to say, well, I'd like you to find that there's a claim here for a loss of chance, even though my predecessor, not once but twice, said this is not a loss of a chance case.
Yes, my lord. That is a particularly challenging element of the submissions, and my answer is this: if you actually look, it's a substance over form point. So the first point to make is the judge considered these things and they are in issue through those paragraphs 124 and 130 of the judgment. The second point to make is the respondent, by being sort of fabulously well prepared, anticipated the loss of chance point and dealt with it both in their opening. They highlight that in their skeleton argument. They highlighted this point in their opening, and then they go on to deal with it in their closing submission, so almost a year ago after trial, and then they also deal with the loss of chance point in the appellant's skeleton argument. And then in relation to the substance over form point, in relation to this disavowal of the loss of chance position, in my submission, it's a slightly nuanced point, but it's not quite right that it's a full disavowal, because whilst the first hurdle in my submission is you do have to look at the balance of probabilities, because we're asking ourselves what Kelly and Mrs. Blower would have done in the circumstances. The next step, and Mr. Learned Counsel or leading counsel at first instance said this was a quantification point. The next point is that you have to, just as a matter of law, looking at the Perry and Raleigh test set out, look at the loss of chance piece. And actually, in substance, that is exactly what was done in the written closing submissions in paragraph 118 and 132 of the written submission. So what was said
it's the
doesn't...
submissions that I've been looking at.
Yeah.
obviously 111,
Yes,
when it says, because they were saying it was a loss of a chance.
yes.
And the claimant says, claimant submits this analysis is incorrect. And at 113, in the claimant submission, this is not the loss of a chance.
But
And so you have to say effectively that that's wrong.
effectively, well, in my submission, there is plainly a tension between what's said there at 113 and what's actually put down in terms of the analysis and what is being said at 118.
Isn't this a good argument for saying, because of course this wasn't pleaded at all.
Yes, my lord.
So it's the double whammy. It wasn't pleaded and it was expressly disavowed. So it's a bit difficult for us to say, well, the judge should have done X, should have found a loss of a chance in circumstances where it was said it wasn't a loss of a chance.
I appreciate that it's difficult, but nonetheless, the judge did in fact engage with those loss of chance arguments because he recognised in my submission, further to that Charles Russell speechly test, that there was an issue to be determined if you were in a circumstance where you had a negligent solicitor, and he clearly considered that that would have been required of him, and that was something that was recognised by the respondents as well, which is why it appears to me in my submission they dealt with it in their closing written submissions, because they recognise further to the Perry and Raleigh case law that you would have to deal with that matter, and indeed it's implicitly recognised despite what is said at paragraph 113 in the written submissions that you have to deal with those points, because otherwise you can't get anywhere in terms of your quantification analysis. So yes, it isn't quite right in my submission what is said at 113 if you characterise it as sort of throwing out any kind of loss of chance analysis whatsoever in relation to the TIB. But the primary point that's being made is it's a balance of probabilities in relation to the claimant, and in my submission that's right, looking at what she would have done as a client. But in relation to the TIB, I can't stand here before you and disavow the law as stated by the Supreme Court in Perry and Raleigh. In my submission, we are looking at what the trustee in bankruptcy would have done in the face of Mrs. Blower and Kelly getting this conflicts advice and deciding not to settle a lower sum.
And you say that the way that the judge dealt with that in those last paragraphs of his judgment, where he says things like, but the trustee in bankruptcy had already climbed down a long way, and on the balance of probabilities, I don't think he'd climb down any further, etc. You say that's not dealing with the matter because he's looking through the lens slightly askew.
Well, his lens is slightly askew, but had he sort of had on, to take the analogy further, if he had the right proverbial glasses on, in my submission, he would have looked at things differently. So if it is accepted, let's say that Kelly and Mrs. Blower would have signed up to some form of settlement agreement. In my submission, sort of building on what we spoke about at the very outset of my submissions, he said that the trustee in bankruptcy had climbed down, and that's right. And that's where you get this real and substantial chance analysis, because the trustee had climbed down. He started off higher, but came down to £330,000 and as an offer for Mrs. Blower on an individual basis, and £130. £130,000. If it was £130, that would be fantastic. £130,000 for Kelly, and that's set out in the notes to the mediation itself. So in my submission, there was sufficient information to determine what would have happened in practice on that loss of chance analysis, because the evidence was there. So yes, he said that there was a climb down in relation to offers, and if he had in his mind that the trustee in bankruptcy was dealing with Kelly and Mrs. Blower on an individual basis, here those individual offers that are set out in the notes to the mediation show that that is a significant amount lower. That's a £200,000 odd saving for Mrs. Blower compared to what she actually paid, so over 500,000 odd pounds, and about a £42,000 saving for Kelly, where she'd actually paid to the trustee in bankruptcy 172 odd £1,000 in the settlement.
But aren't we asking a lot of the judge, because the judge moved outside the pleadings as his alternative
Yes.
at the end of his judgment, and what he did there was to follow the structure of the closings on behalf of your clients. So now you're asking him to go jump another hurdle and go into another paddock and do something different, because he did deal with the submissions which had been made in relation to causation and loss outside the pleadings. But you're saying now he should have done it on a basis not before him.
Or I said that's not quite what I'm saying. It's not a basis that's not before him. It was before him that we submitted that there was a conflict of interest. That was put to Mr. Whitehouse in terms, the SRA code of conduct was there in terms, etc. So it's not that it wasn't before him, it's he considered those matters.
No, but
without...
you're saying
sorry.
no, I'm sorry, I'm cutting over you, and that's not fair. I apologise. But you're absolutely saying, using a Lord Justice Akiroli approach, that if one had the right glasses on and had the conflicts issue high up on one's agenda and had concluded that these different members of the family should be separately represented, one might have reached a different outcome. But when one comes to causation and loss, what we're looking at is the Charles Russell Speechley issue, and the judge he decided it wasn't properly pleaded. He then said, okay, I'll look at what I've got. And what he got was what he'd got. And what he got were submissions which he addressed, and the fact that they may not have had conflicts full and centre, he couldn't, and that's why I'm saying you're asking him to jump a hurdle into a different paddock. Was it for him, even at that stage, to say, aha, I must address your further submissions outside the parameters of your pleading, because that would be fair, but I should go further and embroider those, do better than the submissions which have been made, and also include the counterfactual on the conflicts basis. That's sort of what I think you're asking him to do, jump another hurdle into a new paddock.
In my submission, it wouldn't be...
I don't know much about horses. So.
Okay. Neither do I.
So let's not get stuck on that.
Okay, I won't get stuck in a paddock. In respect of what the judge was saying, again, this is proceeding on the basis, he was proceeding on the basis that there wasn't the negligence of the kind that we're speaking about. So again, it comes back to this point of he wasn't looking at it in the right way.
But does that save you this time? Because this time the judge is dealing with your submissions, not your personal submissions, but your side submissions. So that if there was some difference about there being a conflict of interest negligence, that might have made a difference on the causation, then at the very least one would have expected to see that in the closing submissions.
Yes, my lord, I accept that, but in my submission, he didn't deal with the matters at hand correctly, because he didn't accept. I think that you can't sort of disaggregate what Kelly and Mrs. Blower would have done and how that influenced what the judge found in relation to this loss of chance piece. And even when considering the submissions at 118 and 132 in the written submissions, the judge still had in his mind that we've got everybody, even if you've got the negligence piece, you've got a negligent solicitor in the face of what I call the blower blob, the homogeneous mass of blower who have no differing interests and are acting as one. So in my submission, there weren't all of the relevant facts and matters when he was considering even our submissions were not operating on his mind at that time. And also, just to come to the prejudice point in that regard, in my submission, the prejudice, because if there might be prejudice, then really the pleading should be amended. Ultimately, we're somewhat beyond that now in practice. And in my submission, the prejudice is at the lower end of the scale because the respondents did anticipate this point because they had understood correctly in my submission that what the trustee in bankruptcy or Mr. Whitehouse would have done, that would be something that needed to be determined. So they did deal with it in opening, in their written closing submissions. Again, they've dealt with it today in their appellant's skeleton argument as well, because plainly it was something that needed to be dealt with. And in my submission, that's exactly why Mr. Justice Matthews, in fairness to him, further to that Charles Russell Speechley point, he went beyond the pleaded case because he understood that this was a matter for determination. So there was an opportunity for the respondents to put points in that regard, and they did put points in that regard. But as I said earlier, equally, I recognise that if the court is with the appellant in this regard, that there does, in fairness to the respondent, need to be an opportunity if there's a loss of chance piece to be determined by reference to quantification to put matters forward in that regard. And like Charles Russell Speechley, I don't propose that an entire retrial would be appropriate. In my submission, that's not the case, because this would be a function of a prospects assessment, sort of, as counsel would do or a solicitor do. How likely or not is it that the trustee in bankruptcy would have proceeded ahead with that hearing in relation to flat 201 and or pursue Mrs. Blower for void transactions allegedly under the Insolvency Act, where they were separately represented, and that's the like of work that courts like this do all the time.
So the amendment that the putative amendment you're talking about would be in relation to a plea of loss of a chance.
In relation to what the trustee in bankruptcy would have done.
That would be what it would be designed to convey.
Indeed.
So there would never have been such a putative amendment in front of Judge Matthews, because those acting for Mrs. Blower and Kelly would have said, we don't need to amend because this is not a loss of a chance case. It's an entirely hypothetical amendment until now.
Yes, in my submission, you can't escape. So I'm trying to find a reference whilst I'm answering your question. So sorry, or responding to you, because there is. I know what paragraph it is. I'm just trying to find the relevant case. If I could beg your indulgence, just so I can find the relevant reference in my notes.
That's fine.
Sorry. Because effectively the point that I was going to make, and it's neatly put in a different case. Hold on. Sorry, my Judas helped me. It's page 55 of the authorities bundle. It's the case of Loveridge. And in fact, it's paragraph 29 and 55, 29 and 30 that I had in mind.
Thank you.
Just gonna give it a second. And particularly paragraph 30 of leverage.
Paragraph
yeah.
30.
Yeah, paragraph 30 in particular, so I just make sure you had that turned up. It's this piece of where the judge said that he respectfully agrees with the master of the rolls in paragraph 25, so this is in paragraph 30, that the recorder should have intervened in relation to the absence of a properly pleaded case, and that the civil procedure regime expects him to do so, and insists that the case, and the judge should have insisted in that circumstance that the case be put on a proper basis. Now, in my submission, Mr. Justice Matthews was partway there, and clearly, or it appears to me that this is the type of issue that he had in his mind when he went beyond the pleaded case, that the case needed to be put on a proper basis, which is why he was trying to deal with it in that way. But in my submission, it should have been pushed slightly further, because clearly the situation that we find ourselves in now is unsatisfactory, and it doesn't accord with the legal test set out in Perrin Rally in relation to the loss of chance piece. The respondents dealt with it because it had to be dealt with. Mr. Justice Matthews, he dealt with it because, again, it had to be dealt with. But plainly, it isn't satisfactory that point wasn't put perhaps more forcefully to the claimant at first instance, that this needs to be dealt with more effectively, that it just couldn't work. So
I'm back to my paddock and my hurdle.
So
in effect, you're saying, I think, that it should have been dealt with on a proper basis, paragraph 30 of Laveridge, and therefore the judge should have stopped short, said, this is all coming off the rails. We need to deal with this on a proper basis. It needs to be dealt with outside the pleadings, because the pleadings are inadequate in relation to this. And I'm not just going to, therefore, deal with the issues as they arise in relation to the closing submissions on behalf of Mrs. Blower, etc. A proper basis would be if we actually got this thing right and thought about a loss of a chance in the wider sense, in the context of a conflicts breach, and if necessary, we'll have to go away and do that, and then come back, maybe or not. But that would have been the proper basis. So it seems to me that you're saying, actually, rather than what he did, which was deal with the submissions made on behalf of your clients as they appeared, he should have gone the extra mile. He should have jumped his hurdle into his new paddock. That would be proper basis.
Well, to keep going as like a slight horse analogy, in my submission, he was slightly riding two horses in the judgment. On the one hand, he seemed to accept the pleading point taken by the respondent. This point wasn't pleaded. I can't go, or I ought not to go outside the pleading
but if I'm wrong about that, duh.
But then a sort of riding another horse at the same time, said, well, I'm going to go outside the pleaded case, even though that hasn't been put sort of properly to me.
Well, that's not slightly right, because he had the closing submissions.
Yes, indeed.
I think what that lady is saying is, so you got that. In other words, he dealt with, and we're all familiar with that. If I'm wrong, nevertheless, these are my reasons for. That's quite a common approach by judges. But how could it be appropriate for a judge, having gone that extra mile, then to say, notwithstanding that counsel has in terms said this is not a particular type of case. It's the type of case set out in my closing submissions. How can we say that he fell into error in law in failing also to have dealt with that? And that's where I'm struggling.
I accept that, my lady, and as I said to my lord, it's exceptionally challenging in relation to this 113 point, the complete disavowal of the loss of chance point. What I can say is that clearly the judge had in mind, and everybody else in court had in mind, that this is something that needs to be determined. In my submission, that is the bottom line here. If we have a negligent solicitor, it cannot be the case that that person can effectively get off scot-free when everybody effectively recognises that loss may have been suffered and damages need to be apportioned. And in those circumstances, Mr. Justice Matthews was trying his best to get round that blockage. So in the alternative, if I'm wrong, then I would look at it in this way. But in the looking at it in my submission, he did have the wrong proverbial
Will you have your submissions on that?
glasses on.
Now, what else have we?
I think I have covered everything that I intended to say in relation to causation, but just to summarise and to draw the strings together, we say that it was appropriate for Mr. Justice Matthews to go outside of the pleaded case, and that in my submission, where Kelly and Mrs. Blower had received the appropriate conflicts advice, they either would not have settled at all, and this would have gone to fight in terms of the application, or they would have settled for a lower amount. And those lower amounts can be found in the written evidence that you have there following the mediation, to give the court an inclination as to what would have happened where they were individually advised. In relation to what the trustee in bankruptcy would have done in the face of that conflicts advice, we say that a loss of chance analysis is required if the issue is to be determined in accordance with the law as set out by the Supreme Court in Perry and Raleigh, and that the lower court, this matter, if negligence is found, should be this should be remitted just to determine that specific sort of narrow issue of the quantification by reference to loss of chance as to what the trustee in bankruptcy would have done to assess any damages that were due to Kelly acting through Mrs. Blower and Mrs. Blower herself.
Thank you. Anything else? Yeah, well, thank you very much, Ms. Pitt-Williams. That's been extremely helpful, because you've had the very challenging task that faces any counsel taking over a case at this stage.
I'm grateful.
Yes. Mr. Seaton.
With the court's permission, I was going to address ground 3 and then ground 4.
Certainly.
On ground 3, I wonder if the court would forgive me if I start from first principles. There are 4 of them. First one is the learned judge below was only wrong if he went wrong on the basis of the case before him. If authority is needed for that, it's TPR 52.21. This court looks at whether first instance judges have gone wrong. The second basic proposition is that an allegation that the facts give rise to a conflict of interest or a substantial risk of a conflict of interest is, as my Lord Justice Coulson says, a contention of law. But it's a contention of law based on specific particular facts. The third principle is that facts must be set out in a pleading under CPR 16.4.1a, which says particulars of claim must contain a concise statement of the facts on which the claimant relies. And the fourth basic proposition, which follows from those, is therefore that the nature of the conflict needed to be set out in the pleading. And by the nature of the conflict, lady, what we mean is what the conflict actually constitutes, what it amounts to, why there's a conflict, because of this fact and this fact mean that A and B are in conflict with each other. The regulatory position, which was identified by Milena Friend in a powerful submissions, doesn't deal with whether a conflict exists. It sets out the steps which need to be taken when a conflict has arisen. What Milena Friend is saying is that Mr. Whitehouse didn't take the necessary regulatory steps of explaining the position when a conflict arises, which we agree. There's no dispute, you couldn't explain anything about conflicts. But the judge found there was no conflict of interest, so he needn't have gone into that. The regulatory principles only kick in once there's a conflict there, which is based on facts. And the pleadings must set out the facts and therefore the parameters of the case that a person like Mr. Whitehouse and his firm have to meet. And if we go to a different part of Loveridge and Healy, a well-known one, it's page 53 of the authorities book. Page 53, paragraph 23. It was argued that because a right to a home was an issue, and statutory provisions which protect that, then the overriding objective under the CPR of enabling the court to deal with the case justly requires the court to disregard the pleading.
Sorry, which paragraph are we on?
Paragraph 23.
Oh, sorry, I thought it said 20.
I'm sorry.
No, my fault. Thank you, I have it.
So, Melody will see in the opening
Yes.
sentences of paragraph 23 what I've just said. And then immediately following upon that, the disagreement with that proposition by the Master of the Rolls, Lord Phillips. He cites Lord Wolf saying pleadings are still required to mark out the parameters of the case that's being advanced by each party. In particular, they're still critical to identify the issues and the extent of the dispute between the parties. And then the paragraph continues in the judgment of the then Master of the Rolls in terms which are well known, but which put the primacy of the pleadings in a proper place. Now, the pleading in this case, which Milena Friend referred to, is known as paragraph 38A, and that's on page 141 of the court. For one of the core bundle, paragraph 38A. And it says the defendant acted for John Blower and the claimant, John Blower's wife. Acting for both John Blower and the claimant gave rise to a potential conflict of interest in that, properly advised, the claimant had a claim against John Blower's bankrupt estate for the sum of 1.4 million held on trust that arose out of the sale of the Chantry, alternatively 2 million. That's the first sentence. Claim against John Blower's bankrupt estate. And then the second sentence says, however, in the event that the claimant was successful, my lady, I'll come back to that word successful in recovering the said trust monies, those are also important words, the deficiency in John Blower's bankrupt estate would increase by the sum of 1.4, alternatively 2 million, to his detriment. And then there's a final sentence which doesn't particularise the nature of the conflict at all. Now, based on that pleading, perhaps we can look at the position first in relation to Mrs. Blower and then in relation to Kelly Blower. So, in relation to Mrs. Blower, the conflict that's being alleged is, what's being said is that a claim by Mrs. Blower against John Blower's estate would give rise to a conflict between her and John Blower. And what the defendant argued, and argues today, is no, it wouldn't. It wouldn't give rise to a conflict between her and John Blower opposite the trustee in bankruptcy, which is what we're talking about. Because that pleaded conflict only arises if three conditions are satisfied. First is that Mrs. Blower is a beneficiary under a trust, whether of 1.4 or 2 million pounds. The second, and this is a particularly important one, is that Mrs. Blower, through a proprietary claim or a set-off, could recover monies representing that fund. And that's why the key words are the said trust monies and successful. Because if it's successful, and if it's the trust monies that are recovered, because it's a bankrupt estate, it must be because of a proprietary right, being ahead of all creditors, or a set-off. If she was just a normal unsecured creditor, she wouldn't recover anything because the money's not there. Mr. Blower went bankrupt for 4.8 million pounds. So, and it's only then, if it's a proprietary claim or a set-off, that it will increase the deficit in his bankrupt estate to his detriment.
Is that right, in the sense that the numbers would go in the schedule, whether or not they were going to be recovered? So the extent of his bankruptcy on this premise would increase by the headline number.
Yes, my lady, I'll come to that. That's the second part of it.
Okay.
The first thing is she has to have a proprietary. Mrs. Blower has to have a proprietary claim or a right of set-off. And just dealing with that.
That's so she can leapfrog everyone else.
Yes. So just dealing with that second condition first, and with my lady just Asplin's permission, I'll come back to the third, which is to his detriment, which words taken from that. So the second condition, there's no proprietary claim that she has, simply because there's no property for her claim to attach to. He's dissipated all his assets. And as my lady Justice King picked up, of course, banks and third parties have taken for value in good faith without notice. So there's no proprietary claim. There's no money there, and what places where the money has gone to are to bona fide purchases for value. And there's no set-off for the reasons set out in paragraph 120 of the judgment, which is simply these claims were that the payments made to the claimant were transactions at an undervalue. There's no mutuality of dealing under section 323, which the learned judge had previously set out. He'd set out the law on this between paragraphs 104 and 106, the statutory code. And there's no appeal against those. There's no appeal against that finding in paragraph So that's why in paragraph 114, in a paragraph which may, with the greatest of respect to him, have puzzled Honourable Justice Zakharova, that's why the disposal of the trust fund, the end of paragraph 114, also disposes of the allegation of potential conflict of interest between the claimant and the trust.
I'm sorry, I didn't quite hear you.
Sorry, that was
Why the
me.
disposal of the trust fund?
I'm reading from the end of paragraph 114.
Okay,
Also disposes of the allegation of potential conflict of interest between the claimant and her husband. It was the final sentence of paragraph 114 of the judgment that my Lord, your Justice Zakharova focused in on. So this second...
But you say that last sentence relates directly back to paragraph 38A, the
well,
pleading.
It relates to the fact, my Lord, it relates to the fact that she has no proprietary claim because there's no property for it to attach to, and banks and third parties have taken good faith without notice. And therefore, because that's the point he makes in 114. So the essence of this point on the second condition in relation to the pleading is that Mrs. Blower couldn't show that she would have recovered the money and therefore increased the deficiency in Mr. Blower's bankrupt account other than nominal, other than by way of an accounting entry. And that's simply because there's no property for any claim to attach to and the banks have taken for value. Now the third condition, just to return to that, because I know it's something in my Lady Justice Asplin's mind, is the third condition is that this claim of Mrs. Blower's would increase the deficit in John Blower's bankrupt estate to his detriment. Those are the words used in the pleading, to his detriment. Well, it's just wrong to say that an increase in the deficiency would be to the detriment of the bankrupt. There was always going to be a significant deficiency in his bankrupt estate because he went bankrupt for 4.8 million. And there would never have been full recovery. And the whole point of bankruptcy is that it wipes the slate clean, whatever the deficit is. So we say, on that basis, that the judge's conclusions fully disposed of the argument that was made before it. And also that my client's legal submissions and evidence and whole approach responded to that pleading of conflict. That's the pleading of conflict that we came to trial to meet. So that deals with Mrs. Blower. It's pretty much point of law. We've not even gone to the way in which my learned friends' submissions are hampered by findings of fact. This is a point of law. She had no claim because she had no proprietary interest or set off. When it comes to Kelly Blower, the position's even worse because there's no mention in any detail of the conflict, or any detail at all, of the conflict that's being alleged in relation to Kelly Blower. The last line of 38A doesn't adequately identify the nature of the conflict, and it wasn't expanded on at trial. So the failure of the judge to deal with this issue of conflict in the case of Kelly Blower is readily explicable. But in any event, even if it had set out exactly what the conflict was with Kelly Blower, it wouldn't have helped because it wasn't possible. Because there was no conflict between Kelly Blower and her father. The reason why is just because of what's happening. In relation to 201 Parkgate, the flat in Nottingham that she bought 2 years after she bought the first 4, but she didn't buy it.
Well, I was going to say,
Sorry,
I
Freudian.
think you nearly put your foot on a
I
landmine
did,
there.
I did. I'm sorry. And Mr. Blower bought 2 years after he bought the first 4. In relation to that flat, the trustee in bankruptcy is claiming against John Blower's half. He owns half with Mrs. Blower, his wife. The trustee in bankruptcy isn't claiming against Kelly Blower, actually, because as far as the trustee is concerned, she's nothing to do with it, because she's not on the tied one, and nobody's seen any evidence that there was anything to do with that.
And she gets joined to the proceedings in order to argue that she has the beneficial interest.
She joins herself now.
Yeah.
So the trustee in bankruptcy isn't claiming against Kelly. She's claiming against the trustee in bankruptcy for a declaration as to her beneficial interest based on the Mexico narrative. That doesn't place her father in conflict with her. Both are seeking to maintain the idea of a constructive trust in relation to that property, which, as a matter of fact, the judge was very sceptical about. And if the court would look at, because this was put to Mr. Whitehouse in cross-examination. If one looks in the supplementary bond at page 329. This is what was in. This is very revealing. It's page 329, and it's the entry in the top left-hand corner, in the page internal numbering page 165, and it's at line 12. This is very revealing because this is what's in the mind of my learned friend who appeared below. He's cross-examining Mr. Whitehouse. He says, "And you knew, or you know now, I suspect, that on reflection, you should never have acted for John Blower and his family, because there was a plain conflict of interest arising from the fact that the trustee said that the properties were his, and the family said unanimously, the properties are ours. Wasn't that an obvious conflict of interest?" Well, my lady, one hesitates to say, but it's a very revealing question, actually, because what it does, it answers itself. The family said unanimously. There's no conflict. The family are all saying the same thing, which is, Kelly owns this. Kelly's saying it because same reason that John Blower's saying it. If Kelly owns it, it puts it out of the hands of the trustee, out of the definition of Mr. Blower's estate, and so there's no conflict to identify. So I could, if I was very bold, stop there. But what's happening now is that on appeal, for the first time in the skeleton for this appeal, that my learned friend is raising 4 unpleaded ways of alleging conflict in her skeleton, and an additional one that she added in her oral submissions today. And I really should go through them, I suppose, because they're in the skeleton, although it's right to say that the learned friend focused more on the one that's also in the skeleton than on the 4 as well. I'll deal with them now. So, of the 4, the first one is, it said in my learned friend's skeleton that liability under the settlement agreement was greater than the maximum liabilities of Mrs. Blower and Kelly Blower. And it said that that gives rise to a conflict of interest. And there's 2 points about that. The first is, as a point of conflict, This was not put to Mr. Whitehouse in cross-examination, nor was it referred to in opening or closing. Now, it's right that I show the court that this point was pleaded, but not as a conflict. So it's at paragraph 39, which is 142, I think.
142, yes.
It's at paragraph 39A. So this point was pleaded, and it's right that your lordship see that it was pleaded, but not as a point of conflict. It wasn't said that this, the fact that it settled higher than the maximum value, was the point of conflict. It was pleaded, but it wasn't put to Mr. Whitehouse as a point of conflict. Now, that's obviously one answer to this, but there's another answer, which in fact is one that Lord Justice Saccaroli averted to, although he did so briefly because it's so wretchedly complex to explain, which is that actually the claims pleaded by the trustee in bankruptcy had consequences for Mrs. Blower and Kelly Blower, which meant that in reality they faced damages above the headline figure of their claims. And this is getting into the weeds of the pleadings, but it is important. And Lord Justice Saccaroli averted to this. He said, well, the respondent says that the claims were worth much more. The trustee in bankruptcy's claims were worth much more than the £666,000 which Mrs. Blower said they were worth. And that's true, but I need to explain why. So, Mrs. Blower's claim to a trust fund meant that while the sum claimed from her personally was less, about £660,000, the proceedings which her daughter Natalie and son-in-law Nathan, who were not members, faced, included what she alleged was £900,000 odd of her own money.
She said was alone.
So I'll show the court if it will allow me the pages, because the pages illustrate how that works and what the significance of this whole issue around Natalie and me. So if we look at in the supplementary bundle at page 183. Paragraph 20. This is the witness statement of Mrs. Blower. And what she's doing is she's explaining what she calls row 1 and row 2 in a table we'll look at in a moment, which has £900,021 in it. And she says that these two amounts represent loans, two loans made to assist Natalie with the funding of her property known as the Ailing. The two sums of money were transferred to Natalie, came from my trust fund, these sums being my money. I had no advice from Canfield's, but I've since been informed that this means that John held these monies on trust for me, which was always my understanding. John and I never spoke in such terms between ourselves. Those loans should, upon the sale of Ailing, have been repaid to me rather than to the trustee. And then if the court looks up to the previous page, to page 182, there is a table that's meant to be the basis for her claim for loss. And then on the left-hand column, the two sums, the £500,021 and the 400,000, are itemised in items 1 and 2. Now, maybe we now have to look at how this is reflected in the pleading, because there's a nuance. If one goes back to the core bundle, the losses that are claimed it's set out in the schedule, the amended schedule, which is at page 151. I think it's 151. 149, I'm sorry.
Yeah, 149.
Yeah. And so the court will have in mind we're looking for a sum of around 900,021. And in the pleading, there's a different figure, because it says head of loss 1, then there's some narrative for about 8 or 9 lines, and then it says sums paid to the TIB pursuant to the settlement deed by the claimant. 0 properly due, that was Mrs. Blower's contention, and then principal paid to TIB 1342109. Now, the explanation for why that is 1342109, part of her claim against my client, the sums paid to the trustee in bankruptcy in that amount, the explanation for that, if court would go back to the supplementary bundle, is at page 208 of that bundle.
208.
208.
Thank you.
Still in her witness statement. This is the explanation, which squares the circle, as it were. It's paragraph 96 at the top of that. She says the details of what was ultimately paid to the trustee is set out in the following calculations. And the heading is monies paid to TIB. And then we see figure proceeds from the sale of Ailing 842, and then loan obtained by Sandra Blower. So this is money she borrowed to pay the trustee following the settlement deed, 499,994. And then there were costs incurred in forcing the settlement agreement because they were late, 35,000. A couple of lines below. She says that's derived from correspondence between our present solicitors in the office of the trustee. And then she says this, which explains it all. The payment of 842,115, which is shown there, upon the completion of the sale of Ailing, left a balance of the debt of 900,021, before, outstanding by Natalie to me, of 57,906, which I do not expect. So, what she's saying is that 842,115 of this were proceeds of sale from Ailing, which wasn't owned by her, but was said to be a loan from her to Natalie and Nathan, which loan, by her to them, would otherwise have been repaid on the sale of Ailing. That's what she's saying. And she's saying, well, the balance of that loan has been forgiven, and this is why it's relevant. She was treating the payment by Natalie and Nathan to the trustee as discharge for the loan that she'd given them. And, my lady, the essence of the point I'm finally going to is this. Mrs. Blower can't have it both ways. She can't say, on the one hand, that the trust fund existed, so she paid 1,342,109, which is what she claimed in this case. But then also that the claims being made against her were only 666,000. It can't be both. She's saying the trust fund existed, but that meant, because it had been loaned to Natalie and Nathan, that the claims against my client were all the greater. But it also meant that the claims against her were not a mere 600,000.
Sorry, say that again. Say claims against her.
Were not a mere 666,000. They were much, on the basis of what she's saying, they were much more like 1.3 million at least. And had the proceedings with the trustee gone further and Natalie and Nathan lost a trial, then she would have lost her alleged trust fund too. So what it comes to, after that long journey through the figures, is that the correct analysis is that Mrs. Blower was facing claims against her that she considered were far greater than £666,000 in terms of her overall interests. When she looks at her overall interests, her claims against her were much more than 666,000 because they included sums which she said were hers that were paid to the trustee by Nathan and Natalie as part of the settlement. So it's not right, even factually, to say that she only faced claims of 666,000 and she settled for, she had a joint liability for 1.5. It's not right. And when it comes to Kelly Blower, well, she can't really say that she settled far above the value of the claims against her because there was a cap on her liability of 150,000. But in any event, the claim, if she'd have, the claim what would have happened if she'd have lost on 201 Parkgate is that the asset would not have been available to her at all. It would have been out of her control and into the hands of the trustee. As it turned out, she kept 201 Parkgate. And the reason she kept it on her own evidence is because the 9 months that the settlement agreement gave her allowed her to bridge financing which she could repay when another of her properties was sold at a price she was happy with. The reference for that is supplemental bundle, page 151. And Kelly had other issues as well. If Kelly would have fought against the trustee and lost, she would actually have had to account for the rental income she'd received, which would be referable to her father. The claim was under section 284 of the Insolvency Act, so it would have included income on the date of presentation of the petition in 2012. So Kelly,
am I right in thinking that somewhere in the judgment it said that she'd been receiving it but not paying tax on it?
that's another.
So she would have been in bother with the revenue
Yeah.
as well.
Yeah, there would have been two problems. The lady, as ever, is way ahead of me. There's two separate problems. One is she has to account for the income to the trustee because it should have fell to her father. It was properly her father's income, so the trustee can chase them. But the other problem is she's got a huge problem with HMRC because she's not paid tax on any of this income that she said that she received as part of her claims of beneficial owner.
Well, half of it because the trustee in bankruptcy had an interest in half.
Yeah, absolutely, half of it, absolutely half. There is also what we called at trial the unknown claims. Now, one of the interesting things about this claim is by the trustees, if one looks at page 65 in the supplemental bond,
65 of,
the supplemental bond,
yeah, thank you.
The trustee was playing pretty hard because what happened was a mediation was arranged for the 9th of December 2015, and in the run-up to that mediation, they sent this letter on page 6. Their solicitors sent this letter on page 65, which is ramping things up by averting to other claims. So if one looks at the bottom of that page, it says, as referred to in the telephone conversation between your Robert Whitehouse and our Martin Knefrich, the trustees instructed us to issue proceedings against Sandra Blower in respect of various claims totalling in excess of £1 million. A copy of the draft application of the insurer. Please note our clients now received an offer of adverse costs funding in respect to that application. So you have an insured trustee in bankruptcy whose attitude to this mediation is, oh, I'm going to ramp this up in the last few weeks by threatening other claims. As it happens, the draft application that was attached doesn't add up to £1 million. But the trustee at the mediation did note the future claims. We have notes of what was said. It's not 100% clear how they would have got to £1 million, but it's clear that the trustee and its solicitors thought that such claims could have been made.
So the application
Yeah.
at the back doesn't add up to 100
It doesn't add
million.
up to £1 million.
But weren't we told that they'd got someone busy drafting away for a further claim, which might
possibly,
try because
Possibly, yes. That's why they were called unknown claims. They were unknown unknowns, but they'd been referred to.
Yeah. trustees instruct us to issue proceedings
Yeah.
in
but they
various
said-
claims totaling £1 million. So that means the application annex plus the one that somebody
yes.
in a darkened room was
Yes.
busy drafting.
Yes. Yeah. So what it comes to, my lady, cutting through this, is on this first unpleaded allegation of conflict that they paid more than it was worth, or more than was being claimed against them. And I will finish on that. The headline figures of the individual claims are not a reliable guide to the value of the trustee in bankruptcy's claims against those family members.
Thank you.
And both Kelly and her mother, Mrs. Blower, stood with weak cases to lose more than what was pleaded against them. And in the settlement, that was the risk that they were buying off. Because this settlement, which Blower family have been so keen to undermine, was a joint settlement. And that meant that the pain could be spread amongst members of the family generally, which is exactly what happened. Those with the broader shoulders in the family in terms of assets paid more. And in fact, as we'll see, I won't take long after the short adjournment, but we'll see that actually Mrs. Blower, as a result of this settlement, paid less than the 666 that was being claimed against her. She actually paid only 535. We'll see that later. So where I am is, I said there were 4 unpleaded allegations of where it put in conflict. I dealt with one, the others are much, much quicker.
Yes, I'm just concerned about the time, really.
Yes, and then I will move on to ground 4, but that's where I say, well, as the court will see, it's very specific factual findings.
Very well, thank you very much. 2 o'clock, please.
All rise if able.
So let's just see what we're doing.